Do you have a sentencing?
I have Victoria Bailey for
Let's do Victoria Bailey. It's a sentencing.
Victoria Bailey.
So I have Mark Hebert. We're just going to go through the motion.
Oh, okay. Thank you.
Come in.
Good morning, ma'am. Are you Victoria Bailey?
Yes, ma'am. Good morning.
And Ms. Bailey was previously here in court in cause number 25 DCCR 0278, entered a plea of guilty to the third-degree felony offense of assault on a hospital personnel. And I've received that pre-sentence report. Have you both had an opportunity to review the report?
I have, Your Honor. Yes, Chief.
Are there any additions or corrections?
None more objections.
All right, Ms. Bailey, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include being on the specialized mental health caseload. That'll make sure you have anything you need in order to be successful. So you can get your any drug treatment, mental health treatment, and it's important that you follow through with everything that they recommend. Even if you don't think it's necessary, it's going to be court ordered that you go through whatever program probation says you need to, okay?
Yes, ma'am.
This is a great opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed and you'll never have a felony conviction. So it's a great opportunity.
Yes, ma'am.
The other side of that opportunity, though, is that if you violate any condition of probation, you can be brought back into court and you can be found guilty and sent to the prison for between 2 years and up to 10 years. Do you understand?
Yes.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. It looks like I will be signing also a dismissal in clause number 25 DCCR 0170 as part of that agreement. All right. Good luck to you, ma'am.
Thank you. Thank you so much.
So Mark Hebert's the one we're just going through the motions. Mark Hebert.
Mark Hebert.
Good morning. Are you Mark Anthony Hebert?
Yes, ma'am.
Mr. Hebert, best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You can put your hand down. Mr. Parker, will your client waive the formal reading of the motion?
Your Honor.
Mr. Hebert, in cause number 25 DCCR 0455, I have a first amended motion to revoke your community supervision. It shows that you were placed on probation September 15th of 2025 for the third-degree felony offense of driving while intoxicated, third or more. And that was a 5-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count one alleges that you failed to report as directed to the probation department January 13th of 2026 and December 30th of 2025. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count two alleges that you failed to report to the counselor as directed on January 12th of 2026 and December 16th of 2025. And is that true or not true?
True.
Count three alleges that you failed to report to your administrative hearing that was held on February 2nd of 2026. And is that true or not true?
True.
Count four alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
I mean, it's, you look like your head.
He's self-employed and he's had a business for a while. I think business was slow.
part of the hesitation is he's had some serious health issues. That's why
I mean,
the
if
bond.
it's-
That's why he's hesitant about answering.
Okay,
Not true or true.
so you don't have to say true just because you're here. So is it true or not true that you failed to work faithfully at suitable employment and provide verification of that?
Not sure.
Okay. Count 5 alleges that you failed to submit to alcohol or drug screening January 29th, January 23rd, January 21st, January 13th, and January 9th of 2026. And is that true or not true?
Yes, ma'am, true.
You did all these dates backwards
I
on
know.
this one. Count 6 alleges that you failed to comply with the program guidelines and rules of JCDI program. Is that true or not true?
True.
Count 7 alleges that you are behind in your court assessed fees as of February 2nd, 2026 in the amount of $168. Is that true or not true?
Pretty sure I've paid up on that.
Okay, be not true on 7. Count 8 alleges that you provided a urine sample May 11th of 2025 and April 13th of 2026 that tested positive for marijuana. Is that true or not true?
True.
Count 9 alleges that you provided a urine sample May 11th of 2025 that also tested positive for methamphetamines. Is that true or not true?
True.
And count 10 alleges that you provided a urine sample also May 11th and it tested positive for alcohol. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 freely and voluntarily?
Yes.
The ones that you pled true to, did you plead to those freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing. We will have a sentencing hearing. I'll get the probation department to do an updated report. Ms. Malfino, if you have any, I wouldn't imagine whatever you would have would take very long. If you wanted to have any issues with regard to 4 and 7, you can bring witness and we will get your case taken care of at that sentencing hearing. Anything that you think is important for me to know on your sentencing, make sure you get that to Mr. Parker. He'll present it to me on your behalf when we come back. And
Sure.
for probation, this is unagreed. All right, you can go back with the bailiff.
Better time down in the heavens. Say to you.
Who's that right there?
That.
Oh, okay.
So you
What about Donald DeRusso?
make the paperwork. We've done it. It was lovely. All that. That's Jewish. Right? I don't know what else. It's like
Better checks on that.
Oh,
So I said, you're cousin. Because we're not blood. I said, if you're rich, if you're rich, it's that you think you're funny. He said, yeah, he's my favorite. So, yeah, I guess y'all don't have it. Okay. I'm just,
Yeah. So much. You know, okay.
are you ready for them to bring Donald DeRusso?
Right.
Donald DeRusso? Donald DeRusso.
I call him Duraso.
DeRusso. DeRusso.
I don't know which right. He answered. And again, she's already emailed the.
Thank you. Let's see, and are we going on count one only?
Yes.
That's fine, Judge. His priors make him habitual by law, but he didn't receive even half the time he is on this case on those.
All right, so are you Donald DeRusso? And will the client waive the formal reading of the indictment?
I will, Your Honor.
Mr. DeRusso, in cause number 26 DCCR 0758, you're charged with the state's going to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that's from April 9th of 2026. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. DeRusso is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. Good luck to you, sir. You can go back with the bailiff. Oh, wait. And I am making an affirmative finding of a deadly weapon. All right. You can go back with the bailiff. Goodness gracious. Need a recording of myself. Mr. Lewis, you've got Avriona Dorsey.
Yes, ma'am.
Good morning. Are you Avriona Dorsey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, yeah.
Ms. Dorsey, in cause number 26 DCCR 0756, you're charged with a first-degree felony. You guys marked off second, but is it a first?
It is a first, Judge,
With y'all's permission, can I change that
Yes, ma'am.
admonishment?
because it's burglary with
With intent.
aggravated assault.
So you're charged, Ms. Dorsey, with a first-degree felony offense of burglary of a habitation with the intent to commit another felony, aggravated assault. And that's from April 11th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year deferred probation fine.
We didn't really discuss fine, Judge.
Typically, there's going to be a fine of $500. I'll look at that at sentencing. Also, part of your agreement, it looks like, is that you're going to enter and successfully complete the cognitive track of the ISF program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Yes, ma'am. State tenders number one.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Dorsey is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing.
Okay.
Right? You can go back with the bailiff.
Judge, I think we've agreed if it's the court will accept 8 on Mr. Harrison, we can
Yeah.
call him back up.
All right, Kenneth Harrison. Thank y'all.
Kenneth Harrison.
And so where did I put on Harrison? Did we go through the whole motion before I stopped and started looking on it? Let me find it. Oh, yeah, we already went through. He pled true to 1, 2, 3, 7, 8. Okay, state abandoned. Okay, we're back on the record with Mr. Kenneth Harrison in 24 DCCR 0544. Mr. Harrison had already entered pleas of true to counts 1, 2, 3, 7, and 8. And you guys have visited, I guess, about my unwillingness to accept the plea agreement, and if you come up with some other agreement.
Yes, sure, we have
And what is that?
for 8 years.
And Mr. Harrison, is that your understanding, and is that your agreement?
No.
And so with everyone's permission, can I make that modification on the agreed punishment
Your Honor, he
recommendation?
said no.
You said no?
Yeah.
Oh, I thought he said yes.
I said yes, ma'am.
He said yes.
I heard it wrong.
Sorry about that. It's been scary.
That's okay. So can I make that modification on this document?
Yes, ma'am.
Okay. So I have here, Mr. Harrison, on the tablet, some documents that have your signature on them. I've made that change to show that the agreement is for 8 years instead of 5. Before you went over and signed these, did you go over them with Mr. Lewis?
No.
Do you fully understand all the documents you signed?
No.
And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Harrison is not competent?
No.
All right, sir, I'm going to find that you entered your plea of true to counts 1, 2, 3, 7, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk with Mr. Lewis. So, Mr. Harrison, in my opinion, you're getting a great deal today. You could have gone to prison today for anywhere between 5 years and up to the rest of your life. And I know you've probably been hearing out of the jail what's been going on with the cases where people have guns and are continuing to use them and possess them. So take advantage of the time that you have, do something better with your life. And when you get out, don't possess a gun. Don't be around anybody that's possessing a gun, because if you are and you're here in Jefferson County, it's going to be a whole lot worse than today. Do you understand?
Yes,
All
ma'am.
right. Good luck to you. You can go back with the bailiff. You'll get credit for any time you've been in custody. Let's see. What about Jermaine Reddo?
Yes, that one, Judge. Meaning Philip talks like that one.
Do we need him out?
I don't.
Judge, what we did, this is the one, he had new charges that were filed. It was a felon in possession of a firearm, and the things that you were concerned about. I've checked with our intake division. They found they refused those cases based on complaining witness,
Okay,
found them to be unreliable.
okay.
So what I would propose to do would be to just go on the technical violation, which would be well, it was 2:09 p.m. outside of his residence. He was arrested for this, and charges were not filed. So I can either dismiss the motion or we can give him a jail sanction for the time that he's been on.
I mean, obviously, should that be AM? Because being somewhere else at 2:09 PM is not a violation. I mean, if everything was.
It was AM. That was just a typo in the MTRP, but that's the only allegation that we would probably move forward on.
Let's get Mr. Redo, please. I mean, you can file a motion to dismiss it and I'll sign it, but I want to talk to him real quick before I sign that. I created a new document, but I'm not doing anything with it. There's really nothing to, this is his second. How did the last one get dismissed? Well, third, is that the? So on these new offenses, the possession of a firearm allegation, is that something that only that uncooperating witness could prove up, or is that something that law enforcement?
There was a question about whose weapon it was.
Because this is the second MTRP that has to do with.
Well, the first one was dismissed because the only allegation was that he possessed a firearm and fell in possession of a firearm, and he had been on deferred, so he wasn't.
Right. But still shouldn't be possessing a firearm while you're on probation, regardless of that. So, Mr. Redo, probably what's going to happen today, based on the information that I've received from the district attorney's office, is that motion to revoke your probation is going to be dismissed. This is the second time that you're kind of getting away with doing something that you probably shouldn't. I want you to understand at this point, I'm going to order that you are on zero tolerance on your probation, that you will be on the high medium caseload and required to do everything that you're supposed to be doing. If you are caught with a firearm, if you're around anyone with a firearm, I don't care who it belongs to, ownership, if you're around it, it is going to be a violation of your probation. I'm ordering a condition of your probation is that you are not allowed to be around or in possession of a firearm in any way, not in the same house as one, not in the same car as one, period, none. So there won't be any question if there's an issue that keeps popping up here with regard to firearms, that if you're around one, it won't matter whose it was or whose it belongs to. It's going to be a violation and it's not going to get dismissed. You're going to end up going to prison. Do you understand? You're on a very serious probation and I have some concerns about what's going on, but you're back on that probation. You still have the same opportunity to be successful. It's going to be up to you to quit doing whatever it is that's going on. Okay. If you have an issue with whoever it is that you're dating or married, then you need to get away from that because that's going to end up getting you into trouble. Right? Okay. You can go back with the bailiff. Evelyn Reyes. What?
In the West, they're being dismissed.
Are these the three she's playing on?
Yes.
Okay. Thank you. That needs to be.
Oh,
Good morning, ma'am. Are you Angela Reyes?
Yes.
And will your client waive the formal reading of the indictment in each case?
She does, she does.
Ms. Reyes, you are Angela Reyes, correct?
Yes, ma'am.
And Ms. Reyes, in cause number 26, DCCR 0265, you're charged with the third-degree felony offense of obstruction or retaliation from December 22nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 26, DCCR 0787, you're charged with a second-degree felony offense of assault on a peace officer. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then finally, in cause number 26, DCCR 0788, you're charged with a third-degree felony offense of harassment of a public servant. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes.
In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like the agreements that you've reached in these 3 cases would be for you to receive 10-year deferred probations in each case. There would be fines in each case of $1,000. You would be ordered to.
No, I'm sorry. I don't know that it was the intent of the state to have a total
Three.
$3,000 fines. I'd be willing to waive the fine until those cases would just have.
So a $1,000 fine in, let's just put it in 0265.
Yes.
And there would be no fine in 0787 and 0788. Is that your understanding?
Yes, ma'am.
Is it also your understanding that you would submit to a mental health evaluation and follow any and all recommendations and treatment beyond that mental health caseload at the
Yes.
probation department?
Absolutely.
State tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. Is there any evidence that Ms. Reyes is not competent?
No objection.
All right, ma'am. In each of these cases, and also part of the agreement is that the state would dismiss all of the other remaining cases. Is that your understanding?
Yes, ma'am.
Then I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation can do a pre-sentence report and possibly get that assessment done, or at least partially done, so that we know exactly what you need when you are released on probation when we come back for sentencing.
Okay.
Okay? You can go back with the bailiff.
Thank you, Judge.
Thanks, sir.
I'm trying to find a new film.
We'll claim you. All right. We'll claim all this and we'll send you. Now I'm going to. So.
Any cases to dismiss?
As this courtroom session comes to a close, one thing becomes clear: every decision made today will shape these defendants' futures for years to come. Some walked away with a second chance through probation, while others left in handcuffs to begin lengthy prison sentences. In the courtroom, every choice carries consequences. The judge's final message was simple but powerful: take responsibility, follow the law, and don't waste the opportunities you've been given. Justice isn't only about punishment, it's also about accountability, redemption, and the chance to change before it's too late. What do you think about these rulings? Were the sentences fair, or should some defendants have received a different outcome? Let us know your thoughts in the comments below.